Innocent, 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 but stuck.
London, busy, iconic, a city known for its attractions and architecture, tourists chasing postcards and palace guards. But for Lescene Edwards, there's only one building that matters today: the Judicial Committee of the Privy Council, Jamaica's highest court. Here, lawyers will argue for his life. He's 4,000 miles away, locked up in Jamaica's toughest prison. Still, thanks to technology, he's watching, clinging to every word. It's been almost 19 years since the mother of his children was shot dead with his gun, and he was charged with her murder.
Former policeman Lescene Edwards has been sentenced to life in prison for the 2003 murder of his ex-girlfriend Aldana Harris in Pembroke Hall, St. Andrew.
For almost 19 years, he's been fighting to prove he isn't a killer. His appeal denied at home. This court in London is his last chance, his final stop. It won't be easy. What happens when the justice system gets it wrong? When innocent people are convicted and sent to prison? When they've exhausted all their appeals but still aren't free? Does that ever happen in Jamaica? How big a problem is it? Is there any help, any hope for people like that? I'm Andrew Wiles, and this is Stuck, a podcast exploring wrongful convictions in Jamaica, how they happen, who they impact, and what we can do about them.
Tell the judge, tell the jury, tell the news, them no hear me. Lose my mind, lose my time, lost my life nearly. Holding on barely, clearly.
Everyone stands as the judges enter the room. There are 5 of them: Lord Hodge, Lord Leggett, Lord Burrows, Lady Rose, Sir David Bean. There is one black person in the room. She announces the matter.
In the appeal of Lescene Edwards against the Queen.
Good morning. Yes.
Christy Brimlow, Queen's Counsel, goes first.
I represent the appellant together with Mr. Graham Hall, and Mr. Poole QC represents the respondent.
Lescene's lawyers will argue 3 things I summarize like this. The handwriting evidence was full of problems. The crime was impossible. The trial was unfair. The note at the center of the Crown's case was what appeared to be a suicide note. It said,
Lescene, I love you always. Take care of my children. Tell my babies I love them always. Tell my family I got a vision that is my time, and that if I go, Ivy will be okay, and Peaches will be fine too. If someone should go, let it be me. Tell my mother all her dreams indicate that this is my time. For the family, love you all. Tell my husband that I love him too.
He'll point out at least 5 problems with the note. 1. How it was discovered. Lescene Edwards' trial took place in 2013. 10 years after the shooting. At his trial, one of the main police officers who was giving evidence said for the very first time that it was Lescene Edwards who found the note. And worse, he said that Lescene pointed the note out to another police officer who just so happened to have migrated and so wouldn't be able to come to the trial to confirm or deny if what he was saying now for the first time
the witnesses
was
will
true.
Be there, and this may well have been what happened in this case, that Mr. Phipps took some comfort from knowing that Sergeant Brown was not going to be giving evidence to contradict him.
Another issue, things the note said that the police never investigated. The night before Aldana died, her mother had a dream.
It's put in the mother of deceased had told him that she'd had a dream, that the mother had had a dream that she was going to lose one of her daughters, and also that the mother had told the officer this at the scene.
The dream was important because if the police had taken it seriously, it could have helped the jury to understand the state of mind that Aldana was in on the day of the incident.
We submit that the mother should have been asked, it should be followed up with the mother as to more detail about the dream. She was asked when she was questioned in court how her daughter had reacted when she said she told her daughter.
She cried.
She cried, yes, absolutely, my lord.
We don't know why she responded the way she did because the police never followed up that information.
And in terms of motive, the jury were considering undoubtedly as a young woman, suddenly she goes and shoots herself in the bathroom. And there was some evidence here, which was not followed through, of a potential motive as to why.
Another issue with the note was how the police collected the handwriting samples.
The day after the incident, I was taken to the Redune Park police station, right? So the day after, the investigating officer take a book and placed it in front of me with the suicide note. And he said to me, he want me to rewrite the information in the book 10 times. And I should write it like how it write and space it like how it space. Now, I was very emotional. I was very distraught, right? So whatever he said to me, I just go ahead. So he gave me 10 sheets of paper and I started to write. So what I did, I would write, if 6 words was in a line, I would write 6 words in a line because he said, write it like how it write, paste it like how it paste. That was his instruction. So I started writing, and after I write about 4 pages, he said to me, I don't want to copy it, I want to write it in your own.
The problem is how you collect the note can affect what you can find from it.
It was agreed between experts, and I'll come on to it, that the method of obtaining a specimen should have been by dictation rather than copying from the disputed handwriting.
And here you get a sense of the power of the police. They ask the investigating officer how you come up with the approach. And him say, him just follow mine.
Number 12, did you seek any advice from anyone before you instructed Mr. Edwards to give you handwriting specimen? No, ma'am. So I understand it, you merely did what you thought was appropriate. Yes, ma'am. There's a complete lack of care as to the collecting of the sample handwriting.
I should not have seen the suicide note, number 1. Right? And they should not have asked me to rewrite the same note. They should have gotten other writings that I did before and compare, and they didn't do that. So they tried to set me up from that point, and I found out that it was a setup.
An impossible crime. Lescene's lawyers turned to the fact that there was no murder because, based on the forensic evidence, no murder was possible. It's an argument that he had made before at his trial, but then it was just his say-so. Now he was coming with proof, with evidence. His lawyers asked the court to accept new evidence from 3 experts.
Angela Shaw, who's a gunshot residue expert, together with Mr. Mastaglio, who's a ballistics expert, and also the report of Gillian Leake, who is the blood spatter expert, if I can call her that.
They have prepared a joint report which now gives scientific weight to all the arguments that his lawyers were trying to make at his trial.
The prosecution case relied on circumstantial evidence. However, all of that circumstantial evidence was founded on error and also on unfairness. If I may deal with Miss Leake first.
Miss Leake deals with blood splatter. So let me explain. There were pictures of the crime scene. The pictures showed where there were pools and smears and drops of blood. They also showed where there wasn't any blood. Like, for example, there weren't any bloody footprints leading out of the bathroom, for example. Blood splatter analysis is important because remember how Lescene Edwards said he found the body.
when I hear the explosion and I jump up, I rush towards the living room because I was asleep. So when the explosion waked me up and I rushed towards the living room and I saw the mother was just getting up. And I said, "Where's Pat?" And she said to me, "Then you're not in the room?" You understand? So when I look, that was when I look and I saw that the bathroom door was closed. And when I opened the door, she fell out. And same time I bawled out, "Mama, Pat kill herself with my gun." And she run, come around.
We know that the door was closed based on the forensic evidence because of where the bullet was found. Miss Lee looked at the blood smear on the inside of the door to test the hypothesis, the argument, the supposition that Lescene could have closed the door, shot her, opened the door, exited, closed the door, and not leave any trace that there was somebody inside the bathroom, and not leave any trace on himself that he had been in the bathroom.
Where she's asked the question, can suicide be ruled out? She answers no. Given the various points discussed earlier, I considered the findings collectively to be more supportive of an act of suicide.
Sir David Bean summed up Miss Leake's conclusion like this.
Mrs. Leake's evidence is it's pretty well impossible to explain how, if this was murder, the murderer manages to get out and a few minutes later be in the living room with not a trace of blood on him.
Angela Shano is a gunshot residue expert. I want to pay attention to the point here, right? Because that'll come up again and again. Remember, Aldana was shot. No dispute about that, right? When the police come, they swab for gunshot residue. They swabbed her hand, they swabbed Lescene Edwards' hand. Some point later, they tested her clothes. There was no gunshot residue on her hand. But strangely, there was none on his hand either. And it turns out there was none on the clothes. It's like a gun never fire, right? But rather than the police and the prosecution stop and figure out why, they start to come up with theories and explanations as to what could have happened. And the theories don't give Lescene Edwards the benefit of the doubt. But it turns out that these theories were masking a really embarrassing and a really frightening fact.
Ms. Shaw considers that the method of using hydrochloric acid, which was used to swab the suspect's hands, is a method that had not been used for several decades in most jurisdictions due to a lack of specificity of the colour reactions for trace elements, inadequate sensitivity and interference of the colour reactions among the three elements themselves. And this, in our submission, is important evidence concerning the reliance that the prosecution placed upon lack of GSR on the hands of Miss Harris Vasquez.
People, when I hear what Miss Brimlow just said, I nearly turn over. The method Jamaica was using in 2003 when they swabbed Lescene Edwards' hands, the method that they were using to test for gunshot residue up until about like 2016 had been abandoned across the world for decades, since like mostly the 80s. It's a method that has been discredited because it gives false positives, false negatives. It says that there is gunshot residue when no gun never did it, and it says that there is no gunshot residue when there must have been a gun present. And this is crucial. This is crucial because remember, one of the prosecution's big arguments was there was no gunshot residue on her hand.
Am I right that the GSR evidence that they produced, tested and produced a complete nil return?
Yes, complete nil return.
So there was a total failure to find any gunshot residue on anything?
Yes. Yes.
Including on Mr. Edwards?
Yeah.
Including on Mr. Edwards. Which...
And yet the absence was said to be tremendously significant.
Yes, and yet in the summing up in particular, there was repeated reference to the lack of GSR on Miss
So
Harris.
whatever the Crown's position is now, it appears from the summing up that at the time of the trial, the Crown was founding on the lack of GSR on the deceased's hands.
Yes.
Because, as you say, there are 3 or 4 references to that as a plank in the Crown's case.
Yes, our submission is certainly at that time it was a central plank in the Crown's case.
Now we reach Mark Mastaglio. Now the third expert.
This is now the ballistics evidence. Whilst it's not possible to exclude homicide, I've seen no firearms evidence of third-party involvement. And the submission is that without this evidence from ballistics and forensic experts, the jury are left simply with the photographs.
This is evidence which will now certainly change everything if, and it's a big if the court accepts it. The court doesn't like to do fresh evidence, take in fresh evidence. When a matter ends, the court like it to end and done. It will look at fresh evidence if it can prove certain things. One of them is that the information that trying to use wasn't available at the time of the trial, or you couldn't get it with just making a little effort. Lescene is saying that he couldn't have gotten it, try his best, because it was very expensive and he used all the money that he had to spend on the handwriting expert to come from overseas.
The size of the bathroom. And
this is now a good point to hear from Tom Poole, the barrister arguing on behalf of Jamaica.
The respondent's overarching submission in respect of the fresh evidence is that no injustice will be caused by refusing to admit it, because we say the expert's evidence, properly analysed, does not go very far and does not cast doubt on the safety of the appellant's conviction.
So the government argued 2 main points why the court shouldn't admit the new evidence, and none of them had to do with whether or not the crime was possible. First, they argued that basically the jury was there, the jury was immersed, the jury went to the scene, they saw the bathroom with their own eyes, and so as sensible people, they were able to make up their minds about what happened.
But again, that's a matter that the jury would have been able to determine for themselves.
The judges pushed back on this idea though, and they raised the point that there is a difference between a civilian, just a random person, looking at something, looking at what seems to be a crime scene, and an expert who has been trained in what everything looks like, looking at it and interpreting it and figuring out what it all means.
When you say these are matters that the jury could have worked out for themselves, isn't it nevertheless important that one has an expert in blood splatter coming along and saying, if the evidence had been there, to the jury, that in my opinion these findings can collectively be far more readily explained if the defence hypothesis were to be true rather than the prosecution hypothesis? The fact that the jury could have taken these matters into account isn't the same as saying, well, this expert evidence isn't of great importance, is it?
My lord, when it comes to Miss Leake's evidence, I do say, with the greatest respect of her, she's not. Had this evidence been given at trial, it is not evidence that would have had any great moment as far as the jury is concerned, given the conclusions that she's reached. So take, for example, the minimum space in the bathroom. That is a point that the jury saw for themselves.
You have to stop and think about all the things that an expert considers when they look at the scene. Compare that to somebody just randomly going into the bathroom and looking and say, well, yeah, I guess it could have happened. It's not the same. Just think about it for a second. Of course you need an expert. When a person is on trial and their lawyer says this or that, many people are going to say, but of course I'm lawyer, she must say that. Not true? If an expert is there who is an independent person, explains that based on the science, the body could not have been moved, explains based on the science, 1, 2, 3, it's easier to process it, seeing it come from an independent source.
Everyone can look at the photographs and see the blood spatter. But somebody has to explain what the significance of it is. You can all see it, but as a layperson, you can't really you can't really understand what it is you're seeing or the significance of it unless somebody explains it to you. And the question is, you say, well, the defence explained it to the jury. and the judge explained it. And perhaps the question for us is, might it have made a difference to the jury if a blood spatter expert had explained it to them, someone who has expertise in this, rather than counsel for Mr. Edwards explaining it to them? Is that where we get to?
All right. This clip that I'm about to play is what was one of the most striking, I'll say that, clips to me. Listen.
The critical point to my mind is the last one, is to her position when she was shot, and to the fact also that the body had not been moved from that into that position, because that was apparent, for example, from where the blood on the floor, according to the expert, matched the blood on her head. That meant that she'd been shot in that position, with her back to the door, and that she hadn't moved from that position until the door was opened, allowing her to fall out. It seems to me impossible for him to have killed her consistently with that.
And that would have been the submission made by the defence in closing, and there was evidence.
Well, is there any answer to it? I mean, if that had been... Well, we're considering the safety of the conviction ultimately. Is it possible? Is there actually a theory even which is consistent with Miss Leake's evidence, if it's accepted?
Well, my lord, there was
as to how she could have been shot inside the bathroom with her back to the door, and the door not opened until it's then opened for her to fall out. I mean, he couldn't have got out of the bathroom, and then it's just impossible.
Well, that would have been something the jury...
Well, is it? I mean, does the prosecution now have any suggestion as to how it could have happened?
I mean, Lord, I'm not in a position to sort of speculate as to how that could happen.
Well, the prosecution had to speculate, didn't they? If they do have to speculate if we're to conclude that this conviction is capable of being upheld. If they don't even have a possible explanation...
Well, my lord, the possible explanation is that the deceased was shot inside the bathroom by the appellant, and
sitting on the floor in the left-hand corner with her back to the door.
Oh, yes.
And then,
how does he get out?
My lord, he would have to open the door, ensuring that the body remains in a seated position. Stepped over the body and closed the door.
And all this without having any blood on him when he walks into the living room either seconds or minutes later.
Look, there is no evidence, and that's, I'm not giving an obtuse answer. I'm saying that it is right to say that this was initially treated as suicide and not homicide, and the police evidence on this came from one person who said that he couldn't find his notebook, but had there been blood on the appellant, he would have made a note on it.
Of course he would. And what about the mother?
After all those years, the prosecution still had not come up with a single reasonable explanation as to how Lescene Edwards could possibly have shot Aldana. And worse, it was as though they felt there was no responsibility or obligation or duty to come up with an explanation. This is the fifth and perhaps the main problem with the handwriting evidence, that it's being elevated by the prosecution to a level where it's above every other form of evidence, even where the other forms of evidence are more scientifically sound and proves that what they said happened wasn't possible.
Your case, as it seems to me, is rather like the way the Court of Appeal put it at page 1 of their judgment, that the principal question is, do you accept the evidence of Mr. Major? If you do, that's the end of the case, because the author of the suicide note must be the killer, whether it's suicide or murder, and that's all you need to know, and the rest of the evidence doesn't matter one bit.
An unfair trial. So you may be asking, all right, if the crime was so impossible, why did the jury believe that Lescene Edwards did it? And one of the reasons is that his lawyers made the points about the crime being impossible, but he didn't have the evidence of the experts to independently certify that yes, it's more likely suicide than murder. That would have made a world of a difference. But there was more to it. This brings us to the third point, the unfairness of the trial. There was enough evidence at the trial. You ever see that picture, the image of Lady Justice with the two scales them? In a trial, the judge's job is to balance the scales them, right? Put the prosecution case, put the defense case when you are making a summary of all the evidence to the jury and helping them to understand the law. The judge in this case put the prosecution's case really well. But then she found it very difficult to put the defense's case, even though there was a lot to put on the defense's case. As a matter of fact, one of the lords in my talk and him a say, boy, when him just get the case and him start reading it, him a look back now at what happened when Lescene appealed to the Court of Appeal. At the Court of Appeal, Patrick Atkinson, King's Counsel, raised about 8 points that the judge never put to the jury. And the man said when him see that, he must say, wow.
Well, in the Court of Appeal, the Court of Appeal set out the submission there, which you could assume was fairly similar at 1913-14, a list of 8 points. When I read that list of 8 points to myself, I thought, well, that's a pretty compelling list of circumstances. And if the judge had given a similar list like that to the jury, it might have made a very significant difference.
Well, my lord, a fair trial doesn't mean that the person wins. There are a number of things that go into making a trial fair, but one of them is that the jury isn't allowed or asked to think something about the evidence which it doesn't say or cannot say. That the prosecution doesn't ask the jury to come to conclusions that there is no evidence for them to come to. But you see that in the story that was told about Lescene Edwards throughout his trial.
Mr. Edwards' full interview was read to the jury, and the jury had a copy of it to take with them. It included police speculation of theories, which was not evidence, but was highly prejudicial, including suggestions to him that he'd been in a fight with Miss Harris Vasquez's husband, and that he had issued threats towards the husband and towards Miss Harris Vasquez, none of which was underpinned by any evidence whatsoever.
Another really unfair thing was that the jury was led to believe that science was on the side of the prosecution, when in fact nothing like that was true.
And the second point Ms. Shaw makes is that more reliable methods could have been used to analyse the samples for gunshot residue. Before addressing...
Well, I would put the point in terms of saying that the method used was one that hasn't been used for several decades in most jurisdictions due to its lack of specificity and sensitivity.
My lord, that is right.
Well, that's a very important point, isn't it, when you're considering whether any inference can be drawn from the lack of finding of gunshot residue?
My lord, the point, though, is that the Harrison and Gilroy GSR testing method was the only method available in Jamaica at the time.
Well, it may have been, but the question is, why wasn't any gunshot residue found? And the argument at the trial was all about, oh, well, you might not have been able to detect it because the humidity in the morgue or something. If you know that, in fact, it's a very unsatisfactory method that doesn't work very well anyway, that casts a rather different light on it.
One of the things that really worked against Lescene, though, was the silence. There are some circumstances where people really want an answer. Lescene Edwards gave as many answers as he could give, but there was one question which he just couldn't answer. It's a question which was clearly right there in the minds of the jury.
Why did she do it? I couldn't tell you. She never revealed that she was going to do it, because if she had done that, I would try my best to stop her from doing it. You understand? So I couldn't tell you what causes her to do it. And that was one of the questions that they keep to bombard me with all the while. Why did she do that? Why would she do that? I was not in her head. I couldn't say it. You understand? Because we were not having an issue. You understand? We did not have an issue.
I wonder how much of the suspicion that land on you comes from the fact that Jamaican people don't want to think honestly or talk honestly about mental health, and the fact that a person can be depressed and you don't know what somebody is going through. And you can't say because somebody married or somebody have money that they aren't going through something personally. You don't know.
Mental health is real, and you see a person today, you talk to them good, and you don't know the issue that person have until you hear on the news that same person just commits suicide. You were the last person to interact with them, so people would come to you and ask why, but you can't tell them why, because you don't know, because they never reveal that side of them to you.
Given all that he was facing, Lescene needed the judge to help the jury to understand his case. But while she told him that, yes, he said he didn't do it, he was saying a lot more than that.
The appellant's cardinal line of defence was, I knew nothing about the shooting and the deceased committed suicide. And the jury were repeatedly reminded of that during the summing up.
But that's the difference between an assertion I didn't do it and an assertion I couldn't do it, couldn't have done it. The latter is potentially more powerful.
Lescene Edwards was arguing that his trial was unfair, and the government of Jamaica seemed to be struggling to respond to it because the examples were so clear-cut. If you told the jury about gunshot residue, the same thing applies to two people, and you tell the jury about it for one person, why don't you tell the jury about it for the other person?
This was, to use the expression was used yesterday, it's a narrative style summing up. What the judge certainly cannot be criticised for doing is not going through all of the evidence in nearly minute detail. And the judge, in so doing, goes through Miss Dunbar's evidence as to the absence of GSR found both on the appellant and the deceased. And so the jury would have been reminded of that, and then would have been reminded of Miss Dunbar's evidence that she gave.
I think the main criticism of the summing up is that although it was a narrative summing up, it wasn't entirely narrative. And all the circumstances pointed out to the jury from which they could draw an inference were circumstances favourable to the prosecution. And I would be interested to hear what your answer is to Lord Hodges' point that when invited to point out some circumstances which favoured the defence, the judge declined to do so.
Well, perhaps let's deal with that.
We'll deal with that when you come to it, perhaps. We better not take you out of order, but if you can mark that as something that I will be returning to.
My lord, yes.
Police Constable Lescene Edwards, who was convicted 8 years ago for the murder of his children's mother, has been freed by the United Kingdom-based Privy Council. In its judgment, the Privy Council criticized the government for the long delay in trying the case and the government's lack of resources in providing expert evidence for accused persons.
Free at last.
I learned the importance of faith and never give up. Even when the odds seems impossible, I learned that who truly stood by you when everything else fall apart, and I learned the value of each day, each breath, you understand, and each person that's older dear. So I'm just saying to Jamaican, just people who hold you as dear, you understand, just stick closer to them, stick closer to family. A lot of people wouldn't know what is happening until it happened to them or somebody close to them. So they won't know until the chicken come through, because you still gonna have people who don't believe that I am innocent, and there's nothing I can do about it. Understand? I know my conscience set me free, and I reach a stage that no matter, I don't think society or anybody can do me anything worse than what the system do to me, right? So no matter what people say about me nowadays, I don't care. I just can't think about people right now. I have to think about myself and my family. I have lost 19 years of my life. 19 years of my life I never lived. So if I worry about what people are saying about me, then I would still not live in. So I can't worry about them. All I have to do is just continue. I just start to live for myself and my family right now.
Do you think that there are people in prison now who are innocent who want help? Do you think they're able to get it?
No, I don't think that everybody who need the help can find, because there's a lot of people who I talk to inside there. Because after a while, being in there for 9 years, after a while I become a teacher. There's a lot of persons in prison today who can't read. And when I tell you can't read, if you write A and ask them what is A, can't tell you says a lot of them are in there. And some of them come to you with them story. And when a person is incarcerated, gets sentenced, lose out on their appeal, I don't think they would have a reason to come to you and lie to you and say, I'm innocent. Like them come to me and say, I'm innocent, I never do. What them say to, and them tell me them story. They were set up. The system never do them right. Understand? So there's a lot of people inside there now who I know are innocent people. And there's no way, there's no system. Them can help themselves. They just don't know how to go about to even write a letter. So they are stuck. And there's no help that's coming forward to help them.